Hi, my name's Doug Miller. I'm an attorney and gift planner here at Ozark Christian College. I want to welcome you to this webinar, Essential Estate Planning Tips. In this webinar, we'll cover some basic estate planning information and give you a few tips to consider while you make your plans. I want this to be practical, useful, and informative. If you've not made any plans, I hope it'll encourage you to get started. I want to be a resource and offer to help you any way I can. My contact information is on this slide, and I'll show it again at the end of the session. Since we're talking about estate planning, we probably should define the term estate. Estate is a legal word that simply means all of your money and property that you own. It includes personal items like your household furnishings, tools, and antiques. It also includes vehicles, trucks, trailers, motorcycles, boats. It also would include your bank accounts and investments, your stock, your retirement accounts, and your life insurance. It includes your real estate, like your home and farmland or rental property. So when I talk about your estate, we're talking about all of your stuff, everything that you own. So estate planning is simply making a plan to direct what happens to your property when you die or become unable to care for yourself. Each person has the opportunity and responsibility to plan for the future. The question is, will you make a plan or not? It's entirely up to you. Obviously, you cannot wait until something happens to begin to plan. If you wait until you need a will, it's too late. You must make plans now while you're able. I've been a lawyer since 1989, and in those 30 plus years, I've worked with hundreds of people. I've seen some good estate plans and some not so good estate plans. The good estate plans provided for their loved ones and the causes they cared about with the least amount of time, effort, and expense for their loved ones. Unfortunately, those who didn't make any estate plans often left behind a mess. In this webinar, I hope to give you 8 estate planning tips. The first tip, consult with professionals. Can I write my own will or download one from the internet? The answer is yes, of course, but I don't recommend it. Ask my wife about do-it-yourself projects at home. I'm not very handy and the results aren't very good. So if it's important, we hire an expert to do it. This week, we hired a tree trimmer to come and take out a dead tree in our yard. I didn't want it to hit my house or my car, and I certainly didn't want it to hit my neighbor's house or my neighbor's car. Likewise, when making estate planning, I recommend that you consult with professionals to get the best results. Many homemade wills are invalidated by courts. Why? Because they lack the formalities to be legally considered a will, like witnesses, notary, and some other formalities. Homemade wills are often ambiguous and can be construed separate ways, and the beneficiaries will disagree on the interpretation. I represented heirs in probate litigation involving a homemade will. The plan of distribution was not clear, and it caused a long, expensive family court fight. So please, don't try to make a will on your own. I also don't recommend that you download a form from the internet. Why not? Typically, they're one-size-fits-all forms designed to comply with the laws of all 50 states. Does one size fit all? No. The form will contain numerous provisions that don't apply to you, whether you're single or married, children, no children, minor children, adult children. It'll just cause confusion. And most internet wills aren't free. For the price that you pay for an internet will, you can, just a few bucks more, you can have an attorney draw up a plan specific for your situation that'll meet all of your intentions and comply with the legal requirements for your state. Stop and think about it. We're talking about your life savings, all of your property. We're talking about providing for your loved ones after you're gone. This is not the place to cut corners and try to save money. It may sound like a good idea, but listen to me. Lawyers will make more money from a contested court fight than they would ever charge you to prepare a simple will or trust. Let me assure you, it's much easier to make a plan now while you're able compared to unraveling a mess after you're gone. If you care about your loved ones and what happens to your property, you should consult the professionals. Now, when I talk about the professionals, I talk about attorneys. As mentioned, attorneys can help you spot the issues, give you some advice based on experience, prepare documents that meet your state's requirements, and help you avoid probate. Accountants also, they know your situation. They can give you advice. They can help you make a plan that makes sense, the best sense for tax purposes. Your life insurance agent can help make sure you have the type of and amount of insurance that you need, and also that you've named the correct beneficiaries on your policies. And finally, your financial advisors. They can help you with your retirement accounts and stocks. Maybe they've appreciated in value and there's some tax due. There's a lot of money invested in retirement accounts, and there are tax consequences to most. Later, we'll learn about using charity to help reduce some taxes. But my point here is, do not try it by yourself. Get some expert advice. We're talking about your life savings and your loved ones. I take the team approach. We should ask each of these advisors for their help. They want to help you. They would much rather help give you advice than try to sort out a problem after you're gone. They want to be a help to you. Let's go on to the second. Prepare for incapacity. People are living longer, and the risk of being disabled or incapacitated sometime during your lifetime increases. Some estimate a third of 75-year-olds and over half of 85-year-olds need some sort of assistance. And a disability can be more financially devastating than a death. However, disability planning is often ignored. Usually when you think of estate planning, you think about what happens to my stuff when I die. But estate planning is more than preparing about death. A good estate plan also covers what happens if you become incapacitated or disabled and unable to care for yourself. Who would you want to take care of you? Who would you want to take care of your property if you can no longer do it yourself? If you do not designate someone to make those decisions in the event you became incapacitated, your loved ones may have to go to probate court and have the judge appoint someone for you. A legal guardian is someone appointed by the court to make decisions about your health and welfare. A conservator is someone appointed to manage your money and make financial decisions for you. And it's not just a trip of probate to get the person appointed as your guardian and conservator, but they have annual reports. There are going to be court costs each year and also fees paid to the guardian, conservator, and the attorney for filing the reports. All of this time and expense can be avoided by making a durable power of attorney. Let me explain how a durable power of attorney works. The idea here is that while you're still able, while you're still competent, you can sign a power of attorney appointing someone, we call an agent, to act on your behalf and make medical, legal, financial decisions for you. So while you're able, you appoint someone to act for you if you ever become unable. You can make it effective immediately, but most people don't want to give some other person that authority when they can do it themselves. Rather, they would rather wait until they were unable. How do we determine when you're at that point of being unable? Typically, I would say it's when I put in the power of attorney that says this does not take effect until 2 doctors say I'm unable to act for myself. Then and only then does it act. That's when I want the power of attorney to take effect, is whenever I can't do it myself. Some people think that husbands and wife can sign for each other. That's simply not true. You're going to need a written document, a power of attorney, to prove that you have the authority to sign even for your spouse. Also, before I leave the topic of power of attorney, I want to mention the authority that you give your agent under a power of attorney ends when you die. The agent can't act for you after you die. So the point here is, don't just make an estate plan in the event of your death, but also the event of your incapacity. Tip number 3, understand joint ownership. There are different types of joint ownership. I'm going to talk about owning property with other people. The first kind of joint ownership is tenants in common. Let's say you and I decide to buy a rental house together. We're business partners, 50-50. You own half, I own half. When I die, I want my half to go to my family. And when you die, you want your half to go to your family, not to the other co-owner. With tenants in common, we're like 50-50 owners, like a partnership. When one dies, it goes to their heirs, not to the other owner. Another way of joint ownership is with rights of survivorship. With rights of survivorship, when one owner dies, his or her half goes to the other joint owners. This is how it works with property owned as husband and wife in most states. When one spouse dies, it automatically goes to the surviving spouse. Well, again, you can own that type of property with other people besides your spouse, children, or even a partner, business partner. Single people are often encouraged to add another person to their accounts in case they were in the hospital or out of town to pay bills. But remember, they could use a power of attorney to give that authority if and when it was needed. So if you do add someone to your account and there is survivorship, realize that you're saying when I die, that other person, whoever outlives the other, is going to receive it all. So I want you to imagine a situation where you have a widow with 5 adult children. She writes a will, leaving everything to her 5 children equally. However, on her bank account, she just lists her oldest son as the owner with survivorship. When the widow dies, who gets the money in that bank account? Does it go under the will to the 5 children? No, it goes to the oldest child by right of survivorship. Does he have to share with the other 4 siblings? No. As you can see, it's important to specify whether there are rights of survivorship when you have co-owners and joint property. How you title your property is very important, which leads to the next tip. Plan to avoid probate. What happens to your property when you die depends on one thing: how it's titled. Property that's in your name only when you die must go through probate. Allow me to repeat that. Property that's in your name only when you die must go through probate. Why? Because you're not going to be there anymore to sign the deed, to sign the car title, to sign the check or the stock certificate. So your heirs will need to go get a court order to have authority to get out of your name only. They'll ask if they have to go to probate. There'll be a question of whether or not you have a will. This time I want to point out that wills don't avoid probate. Wills tell probate what to do. Again, wills don't avoid probate. Wills tell probate court what to do with property that's in your name only when you die. Avoiding probate is a good reason to get professional estate planning advice. The probate process can consume a lot of time, effort, and money. Fortunately, probate is optional. There are several ways you can avoid probate. One we just described, joint tenants with rights of survivorship. If you add someone to your title, your property, like your spouse, or someone else with rights of survivorship, it's no longer titled in your name alone. It doesn't go through probate because it's not in your name only. Rather, it goes to the surviving joint owner. So joint ownership can avoid probate. But beware, when you add a co-owner to your account, you're giving up some ownership, you're giving up some rights and control to that property. For example, if you put someone on your bank account, they have access to those funds. And what happens if that joint owner that you put on there, the adult, you put your oldest son on there, and he goes through a bankruptcy, a divorce, or a lawsuit? All of a sudden, his problem becomes your problems because your property has his name on it. You're giving them access, you're giving up some control, you're giving them some ownership. And if you wanted to, if it's real estate and you put one of your children on your real estate and you wanted to sell it, you're obviously going to need to get that child to sign the deed as well. And if they're married, their spouse as well. So you're giving up some control when you add joint owners with rights of survivorship. However, there is a relatively new way of titling property, and that is to transfer on death. What I could do is title my bank account to Doug, transfer on death, A and B, my 2 kids. While I'm alive, with the titled Doug, T-O-D, A and B, while I'm alive, it's 100% mine. My kids have 0 ownership, have 0 rights to it. While I'm alive, I can change it, cash it, give it away. They don't even need to know about it. They don't need to sign anything. They don't need to do anything. But When I die, it becomes theirs automatically. 100% ownership transfers from me to my 2 kids at my death. All they would need to do is show the bank my death certificate, and the bank would say it's yours, 100%. It does not need to go through probate. Why? It was not titled in my name only. I designated on the title, transfer on death, to whom I wanted it to go. Now, states differ. In Missouri, you can title all types of property to transfer on death: real estate, bank accounts, car titles, investments, stock, and avoid probate. However, not all states recognize TOD on everything. They may on most property or on an account or on a vehicle, but maybe not on real estate. So you'll have to check with your state where you reside. And another way to avoid probate is to create a living trust to own your property. Let me describe how a trust works. First, you create a trust while you're alive. Then you convey property from your name to the trust name so that the trust owns the property, not you. It's no longer in your name only. Therefore, it doesn't go through probate. You appoint yourself as the trustee, as the person managing the funds, managing the property in the trust. I name myself as trustee. And I use the property just as I have all along. I can put property in, I can take property out. The only difference is legally, I don't own it. My trust owns it. But again, I'm acting as my own trustee. I also named a successor trustee for when I can no longer act, either due to death or incapacity. When I become incapacitated, I want the trustee to take over the management of the funds and take care of me. And when I die, I want my successor trustee to do what's instructed in the trust. So I've included in the trust document itself instructions for the successor trustee upon my death. Typically, it's pay my bills and then distribute it to these individuals or ministries. So trusts avoid probate because the property's in my name, no longer in my name only, but it's in the trust name. I change the titles to my property while I'm alive so that my heirs will not have to go to probate court and change them after I die. So that's how transfer on death avoids probate. Estate planning tip number 5, coordinate beneficiary designations. What do I mean, beneficiary designations? As you know, when you buy life insurance, you designate who will receive the proceeds when you die. Those recipients are called the beneficiaries. I pay the premiums, and then when I die, the insurance company will pay the proceeds, what's left, to my beneficiaries. Likewise, IRAs, 401ks, and other retirement accounts also allow you to designate beneficiaries who will receive what remains after you die. Life insurance and retirement accounts can be a substantial amount of your estate. You want to make sure they're going to the right beneficiaries at your death. The distribution of those life insurance proceeds and retirement accounts needs to be coordinated. A couple of problems can arise if you don't keep your beneficiaries up to date. For example, let's say you bought life insurance when you were a single person and named your parents as your beneficiaries. Years later, your parents die, you get married, have children, but you don't update the beneficiaries on your insurance to include your spouse and children. See the problem? If you're not sure who the beneficiary is of your life insurance or retirement accounts, you have to ask the company. The company can tell you who your beneficiaries are, and you can make changes. If you want to change the beneficiary designation, you must ask the company for a change of beneficiary form. You must complete a change of beneficiary form and file it with the company. Remember the widow with the 5 children? She writes a will leaving everything to the 5 children equally. However, she lists her oldest son as the beneficiary of a retirement account, her as the beneficiary of her life insurance. When she dies, who gets the money? The child that was named as the beneficiary. Doesn't have to share it with the other 4. Now you can see why I'm talking about coordinating your beneficiaries. The beneficiaries that you've got listed on your life insurance, on your retirement accounts, that's who it's going to go to, notwithstanding the will. Why doesn't it go under the will? Because it's not in your name only. Life insurance and your retirement accounts are contracts that you have with those particular companies to pay that to the designated people, the beneficiaries, when you die. It doesn't go through probate. Again, the IRA as a designated beneficiary was not in her name only, therefore it didn't go through probate. The money will go directly to the beneficiaries you have listed. So make sure that your plan, which you ultimately want things to be divided 5 ways, then you should list all 5 as beneficiaries of your retirement and your life insurance. Tip number 6, review your existing plan. Is the will I made 40 years ago still valid? The answer is yes, but it probably doesn't say what you want to anymore. If you do have a will or trust, but it's more than a few years old, it might be out of date. Not because the laws have changed, but because your life circumstances have changed. Family members have been born, married, buried. New marriages will bring new names, new children, and new addresses. So it's a good idea every few years, every 5 or 10 years, to get out your estate planning documents and review them and make sure if they still are correct. If the plan in your documents is not what you want anymore, then you should change it. If it says what you want, fine, you don't have to do anything. But more often than not, your circumstances have changed and the plan no longer reflects what you would want to happen. It's easy to change and update your plans. If it doesn't say what you want, you can get it corrected. You can update it. Number 7. Who owns my possessions? We know, I want you to look at 3 scriptures on our possessions. We know, first of all, God owns everything. Psalm 24:1, the earth is the Lord's and everything in it, the world and all who live in it. We know that God is the creator and therefore he owns everything. He's the owner and we're merely in possession of his property. Our possessions are really God's property, not ours. Second scripture, our primary motivation must be love. 1 Corinthians 13:3, if I give all I possess to the poor, surrender my body to the flames, but have not love, I gain nothing. In other words, if I gave my property away, even my life, but I'm not motivated by love, I accomplish nothing. We provide for our friends and our family in our will by love. We give to our church out of love for God. We support missionaries and ministries like Ozark Christian College because we love people who need to hear the good news about Jesus. And the third scripture, we must provide for our dependents. 1 Timothy 5:8. If anyone does not provide for his relatives and especially his immediate family, he's denied the faith and is worse than an unbeliever. God expects us to take care of those who are dependent on us. Who are our dependents? Certainly our spouse and minor children are dependent on you. But what about your adult children? Are they dependent on you? Are they financially dependent on you? Perhaps, but probably not. But what about your church or other ministries you support on a regular basis? Do they depend on your financial support? Would they miss you when you're gone? Yes, they would. When you're gone, they'll have to find someone else to make up for your lack of giving. As a result, I think it's fair to consider your church and ministries you support as your dependents. Many people include a gift in their will or their trust to their church or ministry to make up for that loss of giving. God is the owner, and we're in possession of his property. For that reason, we should pray and ask God for wisdom about what to do with his property when we die. Since we possess his property, we should be asking, what does God want me to do with his property? I want to talk about a legacy gift. A legacy gift is a gift made to a church or ministry that takes effect at your death. It allows you, again, to replace the giving that you're doing while you're alive, and allows you to provide for the long-term financial health of your church or ministry. As I said, your church and these ministries are given a task to carry out the Great Commission, and often they're held back by a lack of funds. But if more people left legacy gifts to these ministries, then they could carry out their purpose and more people could be reached. So how can you make a legacy gift? Well, there's several ways. First is to include a gift to a ministry in your will or your trust. You could leave a specific dollar amount or a percentage. So for example, I give $10,000 to Ozark Christian College, a specific dollar amount, or I give 10% of my estate to First Christian Church. Now, I prefer percentages. $10,000 is a specific amount, but if you only have $11,000 in your estate, that's a lot. If you have $20 million, that's very little. But a percentage is going to work no matter whether you have $100 or $100,000. So consider leaving a gift in your will or your trust to a church or ministry. Second, you could name the church or ministry as beneficiary of your life insurance. So if you're like me, you no longer have any dependents and you really don't need life insurance, I could name my church as a beneficiary of my life insurance. That would be a substantial gift. Again, I bought life insurance to provide for my dependents. That once we're financially secure and we know our kids are grown, maybe I don't need that life insurance and I could put it to work to my dependent, the church or ministry. Another way I could do is a transfer on death. I could title my bank account or a vehicle or a house or other investment to transfer on death to a ministry. For example, Fred and Wilma transfer on death to Bedrock Christian Church. Obviously, if something happens to Fred, it goes to Wilma. It's when they're both gone, would it transfer on death? Would not go through probate, and all of it would go to ministry. Another opportunity would be to give appreciated stock, securities, real estate, or personal property to a charity. So again, if you buy low and sell high, that's great. But the IRS considers that taxable gain. So if you sold the property that you bought low and sold high, you're going to owe tax, capital gain tax on that. However, if you gift that property to a ministry, they can sell it tax-free and you'll get the tax deduction for the full amount. So if you bought stock for $1,000, it's now worth $10,000. That's $9,000 of gain to pay tax on. But if you gave that stock to the college or to your church, then the church will, the tax rate for a charity is 0. So there's no tax, no capital gains tax. And you're going to get a tax deduction for the full $10,000. So it's something to consider if you have property that's appreciated in value and it comes with that tax burden. I want to talk about a charitable gift annuity. A charitable gift annuity is a special kind of investment where you give a charity a set amount of money, let's say $10,000, and they promise to pay you a fixed rate of return for the rest of your life. You also get a partial tax deduction, and it benefits the ministry with what's left over when you die. So I put some current rates here for a single charitable gift annuity. Notice it's dependent, the rate of return depends on your age because the older you are, the shorter your life expectancy. But as you can see, these rates are 4, 5, 6, 8%, which is much better than a certificate of deposit can pay. So if you're living on a fixed income and depending on your income from your CDs, then you might want to consider a charitable gift annuity. Again, unlike a CD, it doesn't go back to your estate when you die. It's going to go to the ministries. But if you have that heart to help a ministry and a need for some income, then again, you should look at charitable gift annuities. If you're interested in this, I can give you a specific one with your rates. And so you would know exactly at your age. This can be on one life, one person, or it can be on 2. It can be a husband and wife or a son and a parent. Okay. You also can name the ministry as a beneficiary of your IRA or retirement account. As you know, a traditional IRA, you put money in pre-tax, it grows tax-free. When is it taxed? When you take it out. Or after your death, when your family or your heirs take it out. However, if you name the church or a ministry as the beneficiary of a retirement account, again, no tax will be paid. That gift will go directly to the charity without any tax. So that's money that went in pre-tax, grew pre-tax, and was gifted with no tax. That's wise stewardship. Along that same line, the tax code requires you right now to take a distribution every year. It was 70.5, but the recent Secure Act changed the age of required minimum distributions to 72. So if you're 72 or older, you have to take required minimum distributions from your IRA each year so that the IRS gets their tax. However, you can direct that up to $100,000 per person per year be directed to the charity instead of to you. The ministry receives the full amount tax-free, and you get to count it as your required minimum distribution. Again, the secret here is don't you take it out and receive it. Tell your IRA custodian or administrator, send that to the charity, send it to my church as my tithe, send that to another ministry. And again, you will not have to show that as income, and it be charged to you on your tax statement. So that's something that right now you're again allowed to do up to $100,000 per person per year. Really want to stop and talk about this as a stewardship opportunity. Many people include a gift in their will, their trust, or their IRA to a church or ministry. My wife and I are leaving a legacy gift from our IRA to Ozark Christian College. We did it from our IRA because we know that if we left it to our children, it would be taxed whenever they took it out. But if we leave a portion of it to the college, it won't be taxed. And it'll allow the college to accomplish its mission of training more men and women for Christian service. So we'll be helping students, we'll be saving taxes, and doing something eternally significant even after we're gone. So again, it's an opportunity for you to do something eternally significant with your estate plan. We've created the Ozark Legacy Society to recognize and thank those people who do include a gift to Ozark Christian College. Again, it can be in one of these different ways: through your retirement account, through a life insurance policy, transfer on death, or just an outright gift in your will or trust. We want people to tell us that they've included Ozark in their estate plan, and so we can thank them and appreciate them. We want to thank them personally. And again, as a Legacy Society member, you'll be invited to special events, have fun, meet other interesting people who love Ozark. We celebrate your decision and want to include your name by permission. You can also do it anonymously, but we know that your example could encourage other people like you to include an estate gift. So you can find more information about it at occ.edu/legacy. There's an online application and a lot more information there. And finally, the last tip: do not procrastinate. Can't this wait until I need it? The answer is no. Let's face it, unless the Lord returns first, we're all going to die someday. And there's also a very good chance that we'll be incapacitated or disabled at some point in our life. Unexpected death or disability can happen at any time. Yet it's estimated that less than half of all Americans have made any estate plans. When it comes to estate planning, many people avoid it, postpone it. They may be afraid to think about their own death, maybe think it's too expensive or too complicated. However, without an estate plan, your loved ones are going to spend a considerable amount of time, effort, and money to settle your estate. So wise people make plans to make it easy for their loved ones. So what happens if you've not made an estate plan when you die? If you've not made any plans, then state law will determine what happens to your property. In other words, the state legislature has written your will for you. Now, as bad as that sounds, they guesstimate that you'd want it to go to your family members equally. That's not a bad plan, not an uncommon plan. But how much do you think they will give? How much do you think the state plan gives to your church or other ministry? Yeah, none. If you've not made any plans, then your loved ones will probably have to get an attorney and go through probate. As I mentioned, with planning, you can totally avoid probate. Money that would have gone to probate court costs and attorney's fees can now go to your loved ones and the ministries you care about. God has given you his property and expects you to direct how it will be distributed when you're gone. What will you do with what God has given you? What could you do with what God has given you? You must take action now and make a plan while you're able. Don't put it off any longer. Thank you. Thank you for watching this webinar. You should be commended for wanting to be a good steward of what God's entrusted to you. I hope the webinar provided some useful information. I want to encourage you to go to occ.edu/legacy to look for more information about specific types of legacy giving and an online application for the Ozark Legacy Society. Again, I want to be a resource for you. Please contact me if you have any questions or if I can help you in any way. I would enjoy visiting with you about your plans. Thank you for your support of Ozark Christian College, and I look forward to hearing from you.